Welcome, everybody, to the last webinar in the 2023 webinar series presented by SPSP and sponsored by Sedgwick Brand Protection. We appreciate your attendance, and we look forward to you hopefully attending next year's programs, where we intend to try to do 12 webinars next year. And we've had a lot of good attendance and hope you've learned and enjoyed them this year. Today, we're going to do really one of my favorite topics, partly because I've dealt with this for over 40 years as both an in-house lawyer and then as an expert witness and an outside counselor. And this is really one of the most important areas, both from a safety standpoint and also from the standpoint of trying to protect a company, as well as protecting consumers, of course, in implementing recalls that are effective and adequate. And I'm thrilled we have a wonderful group of speakers today, both from the CPSC and one of our US experts, of course, and then also an expert recall advisor from Europe is on the panel, and I really appreciate everyone's participation. So we have Rutger Oldenhuis, who is in the Netherlands and helps companies do recalls throughout Europe. Asha Allam is a trial attorney with the US Consumer Product Safety Commission, and is going to talk to us about the CPSC's efforts to help companies make their recalls more effective. And then Chris Harvey, who's the Senior Vice President of Sedgwick Brand Protection and has done, I'll say, thousands of recalls. And if anyone knows how to do an effective recall, Chris knows or can help you figure out how to do one. So with that said, let me just, hopefully my button works there. Whoops, there's our pictures. There we are. You can see us on the screen. So I'm going to do a short introduction on the legal requirements. I always do this every webinar, just to be sure you get a little bit of that, and it's really important in this area. And then Asha will talk about CPSC, Rutger Europe, Chris US, and then Q&A at the end. So what problems do companies have from inadequate recalls? And I'm going to use the term, we'll use the term, I think, probably synonymously, whether it's inadequate or ineffective. I think there are some differences depending on whether you have a lawsuit or not, but we'll use the terms probably, both terms during this program. So if you have an inadequate recall, well, you may need to redo it. The CPSC may want you to reissue the press release, and you go back to the stores or send an email to consumers or whatever. So that's one problem if you get a very low response rate, which, as you all know, you mostly get pretty low response rates. But in addition to that, there are all kinds of other problems that can happen. Of course, to those where you haven't recalled the product, they can be injured or suffer damage. And these can result in individual product liability lawsuits. And we're going to talk in a moment about the law on recalls that could come up in a product liability case. In addition, plaintiffs' lawyers love recalls because if their client's been hurt by a recalled product, they have a lot of things to talk about and a lot of things to allege. But in addition to that, there are class action lawsuits being filed today and have been filed for inadequate recalls, inadequate remedies in a recall, and loss of value of the product. So I won't say every recall results in a class action lawsuit, but certainly the big ones do. And of course, these lawsuits are brought on behalf of everybody who owns the product, and they haven't been hurt or damaged. They have a product that's unsafe, and we'll say the remedy is inadequate, or they have the product and they can't use it anymore, and the company's not offered to replace it or whatever's going on. Secondly, or thirdly, the class action lawsuits by shareholders, because the stock value has gone down because of the announcement of the recall. So a lot of the cases are being brought. So every huge recall, you're seeing these kinds of additional legal actions being brought. Lastly, state legislatures, state attorney generals have gotten interested. Congress has gotten very interested in recalls and whether the remedy is adequate, whether how consumers are reacting to it, how effective they are. So this is a pretty important area. So, but I want to first talk about the law in addition to the law involving the CPSC or any other government agency or the EU that talks about recalls. There's in the common law, and the common law is court-made law through appellate courts or trial courts. So it's not official law, but although it could be adopted by a state legislature also. So since the 1950s, the courts have been saying, hey, manufacturers have a duty after sale to warn consumers if there's a hazard that arises after sale. And all hazards arise after sale. So even if the manufacturer didn't know there was a hazard and sold a product that they thought was safe enough, and it turns out it wasn't, and people start getting hurt, the courts have said you have to warn consumers about that hazard. Now, they didn't say you have to recall the product. They said you have to warn them about it. So we call this legal concept post-sale duty to warn. Now, this is the broadest legal duty in product liability. It lasts forever. It involves all the products you sold until you discovered the problem, and anywhere in the world. Now, the legal basis of the claim is that you should have done more. You were negligent. You failed to exercise reasonable care in warning consumers about the hazard. So, and I've had cases where we retrieved all but one product in a recall, and that last product hurt somebody. Plaintiff claimed we were negligent because we didn't retrieve that product from that person. So when you do a recall and somebody gets hurt and they didn't see the recall notice, the jury gets to decide whether the manufacturer could have done more. And in most recalls, you can always do more. And it's a different cause of action from strict liability, which I'll talk about in just a second. But it's very hard to defend these cases because the plaintiff can always allege you should do more. And most awards of punitive damages in product liability arise because there's some allegation that the manufacturer didn't do a very good job after they learned about the safety problem. So it's a very important duty, and one that plaintiffs' lawyers love to throw in their lawsuits, whether they've got good facts or not, just because it'll scare the manufacturer and maybe into settling a case that shouldn't have to be settled. So the common law makes it a balancing test. How high is the risk of harm with the safety issue that was identified, and how easily can you find consumers and adequately or effectively communicate to them about the hazard? So it's a balancing test, and that's those of you who know the law part of it, that's what negligence is. It's a balancing test: the level of risk, the difficulty of reducing the risk. So there are two claims in a product liability case. One, the plaintiff alleges that you sold a defective product and that defective product hurt my client. Or secondly, that you didn't sell a defective product, but that you learned about the defect after sale, and it became defective after sale, and you failed to adequately warn my client about the hazard so that they could protect themselves. So the result of these two different claims is that even if you didn't sell a defective product or they don't have any evidence of it, if you were negligent post-sale, they can still allege violation of the post-sale duty to warn. Now, the law is pretty clear. There is no liability in the common law, now we're talking about in product liability, for a failure to recall your product unless the government requires a recall. And as we all know, there are virtually no mandatory recalls. It happens very infrequently. So, 98% or 99% of all recalls are voluntary. So if the manufacturer voluntarily recalls the product, and they do a crummy job, and that product hurts somebody, you're going to have to defend yourself against this claim. So what it means is if you're doing recalls, you got to, whether you've had injuries or not, accidents or not, you've got to think about how you're going to defend yourself in front of a jury in the event somebody's hurt. Now, I have served as an expert witness in product liability litigation for over 20 years on recall adequacy. And it is really hard to defend these cases because, again, the plaintiff can argue you should have done more. So we can say, well, we did everything the CPSC told us to do, and they're the experts. I mean, that's one of our defenses. But as a legal matter, that doesn't really adequately protect you in the case. So, because you can always do more than the CPSC requires. So this whole issue about recall effectiveness and the efforts to make recalls more effective is a pretty important topic. So that is the law generally. And so you got things other than complying with CPSC and EU requirements and best practices that Chris will talk about. There's a lot of other things to think about, and you have to worry about both the products in the US and the products you sell worldwide, and recalls that are being done even outside the US could come into a US product liability case. So I just wanted to open with that, just so you understand how broad the topic is and how important it is to everyone. But we're now going to focus on the first two speakers, at least on what the governments are saying about recalls and how effective they have to be or should be, and how you can make them better. So with that said, I want to turn it over to Asha to talk about CPSC.
Thank you, Ken. Good afternoon, everyone. My name is Asha Allam, and I am a senior title attorney in the Division of Enforcement and Litigation of the CPSC's Office of Compliance and Field Operations. As is customary, I just have to share my disclaimer that the views and opinions expressed are my own and do not necessarily reflect the view of CPSC or any of its officials. So we're here to talk today about CPSC's recall effectiveness measures and what companies can do to improve recall effectiveness. I think it might be helpful to start with a definition. So CPSC's website actually provides such a definition. And recall effectiveness is defined as the degree to which a recall is successful in improving consumer safety by producing the desired results, including but not limited to mitigation of the hazard, notifying consumers of the problem, and appropriately encouraging consumers to take action. Now, I think this is a really good definition because it really does look at the impact of the recall in gauging its success. As everybody knows, CPSC is continuously improving recall effectiveness. In addition to conducting a recall effectiveness workshop a few years ago, since that time, the Government Accountability Office conducted and completed a study of CPSC and issued 5 recommendations. 3 of those recommendations related to recall effectiveness, specifically verifying firms' implementation of recalls, monitoring firms' progress, and measuring recall effectiveness. All 5 of those recommendations from GAO were closed based on CPSC's successful implementation of those recommendations. As of late, firms have been very proactive in undertaking voluntary recalls, and those firms have actually seen many of CPSC's efforts to improve recall effectiveness firsthand by increasing consistency, transparency, and accountability in firms' written corrective action plans. The elements of these written corrective action plans are, no surprise to anyone. They are listed in 16 CFR 1115.20. And, those are pretty much the same elements that have been required of firms, for years, if not longer. CPSC's fiscal year 2024 operating plan also emphasizes recall effectiveness with improvements to consumer awareness of recall information and recall response rates. So all of these things contain sort of 2 recurring themes, notice and remedy. And those are, not new requirements, but they are codified in CPSC statutes. With notice, course, the goal is public awareness. And, Ken talked about that from the private sector to some extent, but, some of the priorities that we have focused on or emphasized are direct notice as the most effective means to reach consumers and elicit recall participation. And in some circumstances, because of the effectiveness of direct notice, CPSC has engaged less than the full court press to, if a firm can show that it can contact nearly 100% of its consumers of the relevant products directly because of the effectiveness of direct notice. The other thing to keep in mind is that, as we all know, technology moves faster than the law. And so, the statutes are not always going to reflect the most current or most effective technological mechanisms of communicating with consumers. In this particular arena, firms' marketing budgets probably show that social media and digital advertising, for example, are more useful or more impactful than radio or print ads these days. And CPSC has embraced that technology and public notice as well. As many have seen, we have been more assertive in our public notice via social media platforms, and many firms have been doing the same. I think a helpful framework to consider when determining what the most appropriate means of notice might be in a particular matter is, if you leveraged, or if a firm leveraged technology to get a now recalled product into commerce, then they perhaps should leverage that same technology to remove it. That said, of course, there's no universal formula for the appropriate form of notice. It in every case may differ and depend on a number of factors, such as the type of product involved, the type or severity of the hazard and affected population of consumers, the volume of products, how the products were sold in the first place, and things of that nature. The other part of notice that CPSC has been emphasizing is communications to third parties like retailers or distributors to make sure that they are fully informed of the recall and their obligations, whether that's to return products back to the recalling firm, to notify consumers who purchased from those parties, or other obligations. Now, the second sort of pillar in this, in the statute and in some of the focal points in the CPSC's fiscal year 2024 operating plan and other improvements are around the remedy that's appropriate in a recall. Of course, the goal is always to mitigate the hazard, which means that a firm doesn't need to just have a remedy. The firm must prove that their proposed remedy actually resolves the hazard without adverse effects. Otherwise, a refund may be the only option available. The remedy must also actually remove hazardous products from commerce. It's not enough to just issue a refund. This requires, recalling firms to either recover recalled products from consumers or otherwise have consumers document destruction or correction as part of the recall. This also entails stricter quarantine and reverse logistics requirements, such as managing third-party logistics providers. Again, the obligation is on the recalling firm that introduced the products into commerce to make sure that they're effectively removing them. The other part of this is that, the collective we, need consumers to implement the remedy. It's not enough to just notify consumers, hence having the second provision in the CPSC statutes that talk about appropriate remedies. Part of that is firms needing to incentivize consumers to both respond to the recall notices and participate in the recall to remove or correct hazardous products in their own households. That is not necessarily a simple task because it requires communicating a hazard clearly so fewer consumers disregard the recall or disregard the information and warnings provided therein. Consumer ease is really important. We want to make sure that there are few and simple steps that consumers have to undertake to get a remedy. There's less documentation that is required of consumers. There are shorter wait times for receiving the remedy, whatever it is, so that consumers, especially in the case of a replacement or repair, so that consumers aren't in the interim using a product that they have been informed is potentially hazardous. And it also means having functioning websites and customer support or consumer support. We'll note that consumers do contact CPSC when they've tried to participate in a recall and were not able to avail themselves of the remedy. So if a firm's website is confusing or if it's glitching, we're going to hear about it, and then you'll hear about it. So the last part of an effective remedy, of course, is creating a value proposition for consumers. And I think that, my opinion at least, is that we've done a pretty good job of working with firms to, support creativity here. Some firms have offered both a full refund of the product, which is consistent with the statute, but also a gift card in addition as an incentive to get consumers to bring a product back to a store or to return it or destroy it, especially where, recalled products are low-cost items that consumers might be less motivated to undertake the time and effort to participate in a recall. The other thing that we've seen some firms do is providing approved replacement products that can offset any lost functionality or prospective replacement costs to a consumer in order to motivate consumers to participate. That can be something that comes into play sometimes in the context of an appliance where, a consumer may have expected to get a certain number of years of use. And, a firm is entitled to provide a diminished refund based on reasonable use, but that's less likely to incentivize the consumer to participate in the recall if they would then have to take that diminished or reduced refund and then put in more money to replace the product that they've now had to surrender essentially. The last component on this recall effectiveness in terms of where CPSC has been sort of focusing its efforts is, we have to check our progress. And that's where recall monitoring comes into effect. We're asking firms to provide monthly reports on corrections, incidents, and their communications with consumers, distributors, and retailers and other parties in the supply chain. I think a lot of times these requirements can be seen as, check the box exercises, but I want to emphasize that that is genuinely not the case here. These reports are very important. They are indicative of whether a firm's corrective action plan is actually working. And I think that is a really important point to make here. A firm will go through a lot of effort to get a recall announced. This is the progress report. This is the report card to see if you're doing a good job. And failing to file these reports in a timely manner, if you're doing a good job, you should get credit for it. And if you're not, because something unexpected has happened, then the sooner we find out about it, the collective we can address it. Oftentimes a low response rate or a higher number of post-recall incidents. We get notified of that through the monthly progress reports that the firms file, but we also can get notified of this through other means. And that can oftentimes indicate to us whether or not either the notice or the remedy may be inadequate, and facilitate further discussions with the firm. In addition, with these monthly progress reports, are not they're not contemplated as continuing in perpetuity. So seeing the changes month over month in the recall participation data can help inform us as to whether a recall reannouncement is needed if we haven't seen the types of corrections that should be expected for the particular product or hazard, or whether a case can be closed. I mean, that's not to say that the recall closes. Of course, the public notice and remedy should be available to consumers, but the need for further reporting can be suspended if we're able to see adequate progress has been made over, a reasonable period of time. So I just also want to close with a note that, we're talking about recall effectiveness, obviously this is the right thing to do if you're going to undertake a recall, is to do it well and to do it effectively. But I think it's worth noting that failing to implement a corrective action effectively could subject a firm to civil penalties among other consequences. And, I think this is just my opinion, but I think, that may be why some firms are going well beyond CPSC's requirements to produce the desired results of a recall. And I think it would be nice to see more of these efforts in 2024. With that, I'll say that there are a number of public resources on CPSC's website concerning recall guidance and recall effectiveness specifically. You can, poke around on the website, or you can just search CPSC recall guidance or CPSC recall effectiveness, and you should be able to find these resources, which are periodically updated. So thank you for your time, and appreciate you all taking the moment to hear from us.
Thank you, Asha. I put that slide up there to introduce Asha, but she didn't have any slides, so I apologize. I should have mentioned that. Some people were thinking that they were missing the slides. So no, there were no slides there. One other thing I'll mention, because you just mentioned it, Asha, is we'll be posting various things on the website tomorrow, along with a link to this the video for the webinar and the slides, which will be some of the material that Asha's talked about and Rutger's talked about, and Chris may have something to throw into the mix there. So we'll be providing information for you that's been referred to during today's program, or links to CPSC website or the EU website where you can find other material on this. So let me turn it over to Rutger now to talk about the EU, which is doing some current important things that should be of interest to everyone.
Thank you, Ken, for your introduction. Next slide, please.
Oops, just a second here.
And just a very quick introduction. My name is Rutger Oldenhuis. I'm a lawyer. I've been an in-house lawyer at a multinational company in Europe for about 17 years, where I was also responsible for managing the international recalls. And almost 3 years ago, I started Recall Desk. I'm founder and owner of Recall Desk, a company that helps companies with their product safety challenges, including managing recalls. Next slide, please. So Ken asked me to also spend just one slide on the legal requirements in Europe, where Ken explained very briefly the legal framework in the US. I have a few bullet points here to explain the legal requirements and the process of managing a recall in Europe. So in Europe, there's no common law in that sense. In the European Union, we actually have EU law that mandates the implementation of corrective measures in the event of unsafe products. And you can find that in either product-specific law or sectoral law, but also in the General Product Safety Directive, which is a safety net a legal safety net for consumer products, and almost all consumer products are covered by that directive. Corrective measures can be either voluntary or compulsory in the European Union, and most, if not all, recalls that I've been involved in were voluntary. As a company, if you take yourself seriously, you would really like to avoid compulsory measures, so measures that are adopted by member states, by the authority of member states, which is typically then an administrative decision. So speaking of corrective measures, you can think of quite a number of different corrective measures. And a recall typically is a last resort remedy. So how do you know what corrective measures are appropriate for a suspected unsafe product? Well, typically in most cases you would have to carry out a risk assessment, and I call it here a post-market risk assessment or post-sale, which is a bit different in Europe than a pre-sale risk assessment. We have actually a methodology a guidance here in the EU how to carry out that risk assessment. And very quickly, it's about the severity of injury times the probability. And you have to do that in accordance with a certain methodology. And the outcome of that risk assessment typically can lead to 4 different risk levels. It's low, medium, high, or serious. And depending on the risk level, you know what kind of corrective measures are appropriate. And only if the risk level is high or serious, you can almost be sure that a recall is the appropriate measure to take. Now, different than in the US, obviously in the EU, we have 27 countries, 27 member states, and therefore also at least 27 different authorities. Of course, depending on the type of product, you have a lot more authorities. So how do you manage a recall if you have a suspected unsafe product? You are planning to take voluntary action depending on the outcome of the risk assessment. Let's say you have carried out that risk assessment and it indicates a certain risk level. What's next? Do you have to talk with 27 different authorities? Well, luckily not. You are allowed to approach only one member state, and that is called either the leading or the main member state. And if, for example, if you have a headquarter in Europe and it's based, for example, in the Netherlands, typically you would go to the authority based in the Netherlands. But it's up to you. You can basically shop between the different authorities. I had clients that, for example, had a suspected unsafe product that was used during winter sport. So typically you only are dealing then with the Scandinavian countries and perhaps part of France, Switzerland. So you may have the policy as a company to then refer to, for example, the authority in Sweden. But this is pretty efficient. You only have to speak and discuss and perhaps negotiate with one main member state, and this member state then would have to approve the risk assessment and therefore the risk assessment. And beside that, you also propose your corrective action plan. You have to explain how you are going to recall the product from the market. What is your communication plan? What media channels are you going to use? Etc., etc., etc. And this corrective action plan also has to be approved by that main member state. And typically, the other member states basically trust and accept that the approval of that main member state is okay. So they typically are not involved in that process. Of course, they can ask you certain questions or can approach you, but my experience is that they are not very active in that respect. So once you have done that process and you are aligned with the leading member state authority, you can start the execution of the corrective action plan. And same as for the CPSC, typically the leading member state would have to monitor the effectiveness of the recall plan. And with that, I think we come to the next slide, Ken.
Yeah, let me just interrupt for, oops, sorry about that.
Yeah,
is that the first one? Okay. Yeah, let me just say there are 3 slides here that talk about a lot of details, a lot of detail on each of these 3 slides. Rutger's going to have to go through that pretty quickly, so you'll have the slides, posted there, so don't feel like he has to go through each of these and is diminishing the effectiveness of his speech by not going through all of them. Go ahead.
I will speed up, Ken. Okay, so
is that subtle enough?
Yeah, it's very subtle. So there, interestingly, there is a behavioral study on strategies to improve the effectiveness of product recalls, which was carried out by the European Commission in 2021, which will also be available after the webinar. And this study indicates, interestingly, that 1/3 of the consumers who have read a recall notice continue to use the unsafe product in question. And therefore, in the EU, enhancing the efficiency of product recalls continues to be a key focus for the EU Commission, and is also now explicitly addressed in the upcoming EU General Product Safety Regulation. I mentioned earlier the EU General Product Safety Directive. The directive will be replaced by this regulation by end of next year. And this new regulation, interestingly, includes very extensive new recall obligations for manufacturers of consumer products. It's partly a codification of, you know, the common practice, but it also introduces many new requirements that are very specific. And importantly, they also apply to EU product specific law. Next slide, please. Then speaking of those specific requirements in the EU General Product Safety Regulation, I agree with the CPC that direct consumer contact is really the most important element when you talk about the effectiveness of a recall. And I will try to speed up, but when I did my first recall, I think 20 years ago, the distribution channels were still very traditional B2B or B2B2C. And simply, when I was an in-house counsel, we did not have the contacts of the consumer. So typically, indeed, you would have to use the traditional media like newspaper, a poster in a shop, specific magazines. But typically, you see that the response rate was very low, I think lower than 5%. If it was 5%, we were happy actually in those days. A lot has changed. We have social media, we have online sales, we have online platforms like Amazon. It becomes a lot easier also for manufacturers who are typically not having direct-to-consumer contact to contact them. So, but having said that, now in the regulation, it's now codified that economic operators and, where applicable, providers of online marketplaces that collect their customers' personal data shall make use of that information for recalls and safety warnings. And this can be pretty helpful if you make your communication kit. If you are informing your retailers, you can refer to this and say, if you have records of customers who have purchased this affected product in your shop, you are actually supposed to contact them directly. And you can make their lives easy by, for example, providing them with a template, which is what I typically recommend my clients and what I've always done when I was an in-house counsel. So make it easy for retailers to inform their customers. Consumer registration for products. Product registration by consumers for direct notifications regarding recalls and safety warnings shall be encouraged. Yeah, the European Commission may, in the near future, also appoint certain product categories where consumers should always have the possibility to register their name. So this is also important. Clear and transparent recall notices. There are some very specific requirements now mentioned in the regulation. It should be clear, transparent, and describe risk clearly. Therefore, the recall notice must avoid any elements that may decrease consumers' perception of risk, for example, by using terms and expressions such as voluntary, precautionary, discretionary, in rare situations, etc., etc., or by indicating that there have been no reported accidents. I think literally all recall notices that you see today in Europe, include one or more of these words or expressions. So this really has to change. Interestingly, the notice should also must contain a stop use instruction. And this can become pretty interesting because what, for example, about a car recall? I've never seen a stop use your car immediately instruction in a car recall. And there are many car recalls in Europe, and I think it's the same in the US. So it will be interesting to see how this will evolve, because I asked the EU Commission if we should take this literally, and they said yes. So, but it seems that they did not really consider the consequences for example, the car industry, but there are more products that could be affected by this. Next slide, please. Easy contact. It may sound like common sense, but bear in mind that European Union is still 27 different countries with 27 different languages. So this can be a challenge for companies to make sure that consumers have access to more information through toll-free numbers or other interactive tools. But it's now in the regulation, and companies should make work of this. Effective and timely remedies. It's now literally in the law that it says that economic operators are required to offer consumers at least 2 options between repair, replacement, or adequate refund of the recall product, unless that would be disproportionate. So taking the car recall as an example again, I think we all understand, it's common sense that repair is the most proportionate corrective action in case of a car recall. But this will no doubt lead to discussions with authorities on the question, what is proportionate and what is not. And here's another interesting one. Economic operators must collect non-portable products if they are dangerous. So if we combine this condition with the stop use your product immediately, again, if we take the car recall as an example, but we could also think of heavy cargo bikes, for example. This literally means that in a case of a car recall, the consumer should stop using the car immediately, and the car should be collected at the consumer. And also here, I asked the EU Commission, is this really the case? Should we take it this literally? They are still thinking about this behind the scenes. They are working on guidelines. They think the guidelines will offer some flexibility here, but then again, these guidelines carry less legal weight than the regulation itself, and consumers can, refer to the regulation. And this could become pretty tricky in that respect. Perks, indeed, same like CPSC already explained. Incentives like discounts or vouchers could be very helpful to encourage consumer participation in recalls. So that is really recommended also, and now codified in the regulation. Last slide. Ken? Yeah. Yep. So of course, the key question is, when is a recall successful from an EU perspective? It's very hard to say. Is it about effort, or is it about result? I think it really depends on a case-by-case basis and on a product. It really differs. No recall is the same. If we have a company that still uses a traditional B2B distribution method without having any details of the end user, therefore is not able to have direct contact, I think the emphasis will be more on the effort. So your communication plan should show, the efforts you are taking to really try and reach those end users, even though you do not have their contact details. Whereas on the other side of the spectrum, you have the companies that are operating fully online, and basically therefore have all the details, the names, the contact details of the end users. So here you could really focus and emphasize on the results. Basically a 100% response rate in theory should be possible. Of course, this is a sliding scale. You have companies that operate with an omni-channel model. So they have typical brick and mortar, they sell through typical brick and mortar stores. in a B2B way, but they also sell directly to end users through their own website. So here you will see a mix of effort and result. And in the end, this will have to be part of your corrective action plan that you are discussing with the leading member state, which they have to approve and which they will monitor. And finally, they will confirm whether they are happy with the result and basically say, we think that the recall is successful. You've done enough. We can close this case. Same as the CPC already mentioned, important factors for a successful recall is, for example, the product type. If it's a very cheap product, you typically see a very low response rate. But if it's a very expensive product, you would typically expect a very high response rate. Consumer type, if it's a vulnerable consumer like children, you may expect the authorities are really pushing for a high success. It depends on the risk. If it's low, medium, high, or serious, and as I already explained, the distribution model. Last but not least, an intriguing paradox that I just wanted to share with you. I think the more successful a recall is, obviously, the greater the cost incurred. So yeah, it's an intriguing paradox that you see companies are struggling with. The success of online sales using online platforms like Amazon, they've given the company so much success in reaching customers, but at the same time, it's a lot easier for them to have direct contact with the end user. Hence, the recall can be expected to be a lot more successful, and hence the greater the cost incurred. Yeah, the best thing about a recall is not having one. So if you are aware of this paradox, make sure you have your compliance processes in place, and perhaps you should even consider a proper recall insurance. That's it from my side. Giving the floor again to you, Ken.
Thank you. Yeah, I just want to point out one thing, and I'll turn it over to Chris, is that the recall you do in Europe, for example, could come into a product liability case. Because one of the allegations that the plaintiff could make is, gee, you did more in Europe than you did in the US, for example, and that's evidence that you were negligent in the US. So you got to think about recalls in different countries which have different requirements at the same time, and try to figure out how you should do each of these, particularly the one in the US, and can consider how you would defend the adequacy of your US recall in light of the recalls that are going on in other parts of the world. Let me turn it over to Chris.
All right, thanks, Ken. In the interest of time, I'll speed through some of this, but I could definitely touch on different practicalities around recall effectiveness. But I did want to concentrate on consumer behavior with recalls, but also before recalls. And we actually just did an independent survey ourselves of over 2,000 consumers, mostly in the US, but also Canada and the UK. And we're just starting to analyze that data, but I thought it would be beneficial for this webinar to share some of those early insights that we're learning related to recall effectiveness, really focusing on some of the communication preferences, but also motivators for consumers to respond. I think, though, in any survey, there can be some bias. So, those people that respond to a survey, are they more likely to respond to a recall? Maybe. And then I just think self-interest, self-bias can come into play, where people think they're better responders than they potentially are. So I'll quickly touch on 3 areas. So just how can companies be more proactive with being ready for a product safety event, keeping consumer behavior in mind? What are some of the effective ways to notify consumers? How do consumers want to communicate? And then how do you get consumers to take action? Essentially, why don't they take action too? So I think it's important for companies to just understand in general that recalls can be part of doing business. You can't avoid them no matter how robust your quality systems are, your verifications with suppliers are, they're going to happen. So understand that, have a robust recall plan in place that is customized to your business, your model, your product line, and the environment we're in today, and then modify that as those things change. Too often I see a generic plan and companies get themselves into trouble. Once you have that plan, train the team, familiarize them with what needs to happen, and then also run mock recalls to identify gaps or deficiencies. This is going to help run an effective recall, having a clear understanding of the supply chain up and down and who's responsible for what. This is where I think contracts are very important. So those expectations are set up front before a recall happens. So on this slide, as we dig into the data, and before I go into product recall data, I did want to see how consumers normally act when they first use a product. So only a slight majority of consumers, 60% revealed they would review a product safety information before they started to use the product. So that leaves 40% who wouldn't view that. And then the same story is true for review of product instructions. 60% indicated they would follow the instructions provided with the product. But then again, now you have 40% who do not use the instructions properly. The instructions might be intuitive enough, but this may relate to some of the challenges that we see with recalls. So if we look at consumers who are asked if their behavior could be changed or what could influence that change, the most impactful thing was really related, about 40%, was really related to those consumers hearing about other consumers having negative effects by misuse of the product. So that was a big trigger for them to perhaps change their perception. But we did find that 25% of consumers also said nothing would convince them to use the product differently. So I think it's human nature, but important for companies to know that there is a certain population of consumers who will act based on their own perceptions, their own beliefs related to risk and safety, regardless of what an agency or a company tells them. These are probably, those individuals that are hard to get to respond in a recall situation. So if we look at behavior with recalls related to buying and selling, we had 10%, or 1 out of 10 consumers, admit to purchasing product they knew had been recalled, which is baffling. It's only 10%, but baffling. When we consider the secondhand marketplace, 88% of consumers responded with confidence that they never knowingly is important, sold, donated, or shared recall products. So that's positive news, but there is 12% who admitted that they knew they were selling recall product or were passing along recall product or just weren't completely sure about it. So that's somewhat uneasing even at 12%. I will say that 88% can be misleading, I just mentioned, because if we asked it slightly differently, 75% or 3/4 of consumers admitted to not checking to see if a product was recalled before they went to sell it, before they brought it out of storage to use or give out secondhand. That may ring more true, but this is what makes it hard on recalling firms, because you see these incidents pop up years down the road after a recall has been initiated. If we go to the next slide, so a critical next step, and this was mentioned, Rutger mentioned this, is achieving recall effectiveness is notifying the marketplace. So it's important to choose the right notification method. I do think these notification methods should be customized based on the audience. And as Asha mentioned, companies should know from a marketing standpoint how best to reach their consumer base. I do think, again, it should be customized. So like my parents would not want to receive a text message or an email. They'd be nervous it was spam or something else. They want to receive a physical notification. But on the flip side, a younger population may want exactly that, something more digital. I also think a multimodal approach by doing an email and a letter can help drive more response, doing multiple rounds of notices to get people to respond. And that's something I've actually seen the CPSC request some manufacturers, is to do multiple rounds of notifications to get a higher response rate. So more than half of consumers surveyed, they indicated they expect to be notified directly from the company. While media coverage was the second preference among US consumers, we did find that UK consumers would rather be notified via text or some type of social media like the WhatsApp. So again, as mentioned to earlier, it's important to understand those cultural differences and how consumers like to be communicated with. This was mentioned a bit. One of the most important things is direct consumer notification. Asha and Rutger both mentioned this. It's obviously not as easy as it sounds. One of the most common ways to get this information, especially if it's sold through a retailer, is registration cards. The data suggested that 25% of consumers do not register products they purchase. I think this is one of the self-bias aspects, because I think that number is probably flipped, and 75% don't actually register, a very small number from my experience. But this does make it difficult for recalling firms to reach consumers. So we did dig a little bit at that, is how can you increase registrations? When we looked at if the registration was only positioned as a safety mechanism, response could be limited. 30% said that was a factor, a recall or product safety is a factor in getting them to register. Whereas an extended warranty or some other type of product protection, that generated and provided a more compelling case to have them register. Obviously, the more expensive the products, the more compelling it is in that case. 25% did say that they could offer an exclusive offer or a promotion that would drive them to get to register as well. But I do think a combination of all of these would be beneficial to be able to do. I do think communication is a shared responsibility throughout the supply chain. So understanding if retailers have data, will they do the direct notifications, or will they provide the data to the recalling firm? And again, that's where contracts are important. If we go to the last slide here, Ken, so again, notifying the marketplace is half the battle, but it can be very challenging, as we know, to get consumers to act. Rutger's kind of mentioned some of this, but the notice and the call to action has to be very simple. It has to be easy for consumers. Keep the language and how they identify if they have affected product basic. I usually say use a 10-year-old reading comprehension level on what they need to do and make it very easy for them to respond. Provide a good remedy that incentivizes them. And as mentioned before, incentives like a gift card, even if you throw like a $5 gift card for a coffee, human nature, they don't want to miss out on free stuff. So it may actually incentivize them to take action. So consumers that we surveyed, they indicated they take recalls seriously, but from what we know, that behavior isn't always true. 75% of the ones we surveyed said they were likely or very likely to respond to a recall. From my experience, I'm not sure that's exactly true. Only 45% of consumers disagreed with the statement, I may choose to ignore a product recall announcement when I feel capable of making my own decisions about product safety. So that means 55% agreed with that. In fact, 30% of consumers agreed with the statement. They acknowledged that there are at least some circumstances in which they would ignore an announcement. So even though we've got good intention consumers, they may not always take action. And then evaluating consumer behavior, the most often cited reason for not responding to a recall in the survey is, and this was roughly half, is that consumers say they no longer have the product or they don't remember buying it, which that is fair. This is a group that may not respond back to the manufacturer, so it looks like a lower response rate, but when in fact, they may not have the product. About 25% indicated a different reason. And I think this is where the rubber meets the road. This is some interesting intel for consumers. So there's four things. One area said, I don't remember being notified by the manufacturer. So maybe they weren't notified by the manufacturer. Maybe they were and they didn't pay attention. Something to think about. It's too difficult or inconvenient for me to return product. So could the recalling firm made this easier? Why was it too difficult? Something to dig at. The recall product isn't important enough to warrant the effort. I'd rather continue using it, throw it away, or purchase an alternative. And this one in the next survey, I want to unpack, because if they throw it away, then you're removing the hazard. That's fine. If they're still using it, there's an issue there. So I want to unpack that and dig a little bit more. The last one, though, I've used it for long enough and I don't feel I'm at risk. This one scares me the most because maybe they're not understanding the hazard. This is what I unfortunately see with infant and children products, where a grandparent used something, then they handed it down, and now the grandchildren are using it, and it was safe for them, even though there may be a high hazard to it. So I think this is some of the data we can start to unpack to see how do we change some of this to get a higher response rate. And I think it's notable that half of the responses are focused on the manufacturer, The other half is centered around consumer behavior. So again, things to consider around that. So in the interest of time, I'll hand it back to you, Ken. Okay, you Ken.
Sorry, I keep clicking the wrong button to get off of mute here. Okay, we have a few questions, but I think we're running a little bit late there. So let me just get to the right slide here. Is my email address is right there. Those where we didn't answer the question, would you email me your question? I'll get you the answer and email it back to you. There weren't a ton there, but we'll be providing more information on this. There was a question about retailers and telling retailers about recalls. We'll deal with that next year. We're going to have a whole webinar on retailer manufacturer interaction issues. So we'll have information on it. But if you can email me the questions you either didn't answer or you have later, just send it to me. I'll get it to the right person to get you an answer. And I apologize, we're a little bit over. But I think we're doing well. Thank you all of my speakers for participating today. And please take a look at some of the postings we provide to you, which sounds like there's a lot of information to give you. And we hope this has been useful to you, and we appreciate it. And happy holidays to everyone. And thank you all for attending.
Thank you all. Thank you.
Thanks.